to do with the NCLT decision on Essar Steel. Now, you know that last week the NCLT asked the resolution professional and the Committee of Creditors at Essar Steel to review the bids made by ArcelorMittal and Numetal Mauritius. This was in the very first round of bidding. Now, the RP had found both of these bids to be ineligible, as you know already. And the reason why I'm bringing this up early in the morning is not to inundate you with legalese, but there were four very interesting things that I thought in the order are worth noting. And the reason they're worth noting is they have a potential impact not just on how Essar Steel unfolds from here onwards, but what could happen on other insolvencies as well. Now, the first one has no impact on anything except that, you know, it raises a strange question about the Ruya's connectedness to Numetal. So as you know, the RP has deemed the Numetal bid ineligible, mostly on account of its connectedness, and I use the word loosely, with Revant Ruya, who is the son of Ravi Ruya. The RP, in his affidavit, which is reproduced in the NCLT order, said some very interesting things about whether Numetal had a side agreement with the Ruyas or not, you know. And this is something we've been asking Numetal itself, saying, you keep claiming that Revant Ruya has no management control, has no right to appoint anybody on board, you know, has no management rights in any fashion. But is there a side agreement that something like this could happen in the future? Well, the RP says, yes, there is a side agreement. And while Numetal averred that, you know, Revant Ruya did not have any such rights, the RP's affidavit says that Numetal's documents did not categorically state that there was no agreement. And in fact, he says, on the contrary, the documents submitted by Numetal clearly contemplated that there could be such agreements. Unfortunately, that document is Exhibit A and it's not included in the judgment. But that's very interesting. So he is pointing out as an RP to the existence, or potential existence, of a side agreement, which I'm sure is what, you know, sort of influenced his view also in some ways to deem this ineligible. Now, more interestingly, what did the NCLT have to say about the RP believing that both these bids are ineligible? And the reason why I'm bringing that up is you're going to possibly see this in other insolvency cases as well, as 29A comes up for interpretation, and that's the new provision in the IBC that bars certain sets of promoters. When it came to the Essar bid and the Numetal bid and it being deemed ineligible, the NCLT had no disagreement with the RP's views, except that it did not share its own view. It just said something that was very interesting. We do not find any patent illegality in the decision of the RP for declaring ineligibility to the applicants. It's a prudent decision, especially since there is the possibility of more than one legal view. And at this stage, the court is not expected to substitute its view and to interfere with the conclusion of the RP. So that's the NCLT saying, hey, I'm not going to take a view on the ineligibility of the bid at this point in time. But on the ArcelorMittal bid, the NCLT did take a view. They did believe that the ArcelorMittal bid was ineligible, as the bidder, which is ArcelorMittal, had control over two NPA accounts, it's KSS Petron and Uttam Galva, at the time of submitting its bid. And they said that you cannot just disqualify the bid. The process under the law would be to allow for ArcelorMittal to remedy this ineligibility by paying up the overdues as laid down in 29A in the IBC, and then, you know, finding itself to be eligible again if it chooses to do so. So hence it sent that bid back and the entire process back to the RP and COC. The third point I wanted to make is on whether the NCLT agreed with the Committee of Creditors on rebids. And it said something very interesting. The Committee of Creditors submitted that we had two options in front of us, since both these bids were considered ineligible. Either we reopened the process entirely all over again, or we just went back to those who had expressed interest and gave them a chance to rebid. The COC said we picked option number 2.
Okay.
The NCLT said you should have picked option number 1, in our opinion, and we're asking you to consider this, keeping time constraints in mind. And why this is interesting is because this, if the COC reconsiders, could open the door for a direct bid from JSW. So far, JSW, because it did not put in an expression of interest in the first place, could not come in when the rebid was announced. It had to come in as a partner to Numetal. But if on the behest of the NCLT, the COC goes back and says, hey, look, the NCLT has suggested that, we should maybe go with the option of fresh bids altogether, then maybe that's the door opening a little bit for JSW. But time constraints are important because the 270-day deadline is running out. And coming to the 270-day deadline, this is one important point I want to make, not just for SR Steel, but some other insolvencies as well. You know that it's a 270-day deadline set down in the law very clearly with no possible extension to that. Now, in the Bhushan Power case, in one order, the NCLT had said that the period which is to be consumed in litigation would not prima facie be part of this 270-day deadline. In the SR Steel case, what the NCLT has done is relied on another NCLT order, which was undertaken under very different circumstances. So the NCLT has confused matters a little bit. And in the Binani Cement case on Friday, the NCLT made no serious comment about extending the actual period, but just simply extended the duration of the RP's appointment indefinitely till any further orders are passed. And the point I'm trying to make in this is that we now have several different views on extension. And that's going to be a little discomforting, if I can say so, because the efficacy of the IBC relies on doing this in a time-bound fashion. And if you start taking litigation time out of that 270-day process, then the process could go on for potentially, years, if not less, because as you can see, in all these cases, there is extended litigation going on, multiple petitions that have been filed. So what happens then? What happens to that sacrosanct 270-day deadline? These were the 4 points that I just wanted to bring up from the decision. And let's see how this goes from here on.
Just one question. The NCLT at times has given an opinion, at times has refrained from giving an opinion and sided with the decision that has come in, as you said in point number 2 as well. All of these are in line with what the NCLT would ideally should have done. I mean, what's the legal opinion that people are getting?
So different NCLTs have looked at some of these issues differently, and I think some of the confusion will arise from that and eventually only get settled when it goes to the Supreme Court. For instance, how do you view eligibility of a bid? This NCLT, when it came to the new metal bid, has said we don't want to offer an opinion.
Yeah.
When it came to the ArcelorMittal bid, said, oh yes, you're clearly ineligible, but you have the time to rectify that ineligibility. So, within different bids, within different NCLTs, you're seeing different opinions come up, different ways for the NCLT to deal with this. I'm sure at this point in time, it's adding to the confusion. Possibly will get settled only when it goes to the Supreme Court and they lay down the, sort of the parameters on how to view all of this. But I think the most discomforting bit on all of this is the timelines, if they start taking litigation out, could get extended into several months. I mean, Binani has 15 petitions at the NCLT level. Hearings have been going on for days. Then from here will go on to the NCLT level. Then it will go to the Supreme Court. It could take weeks. And if there's no pressure of an impending deadline, this could go on forever, right?
Yeah.
So, well, not forever, but yeah.
But goodbye to the early resolution.
Which is what, look, time costs money. You know that better in the markets than anywhere else, which is what the banks and lenders should be really, really concerned about. So.